Thank you very much. And I would like my esteemed colleagues to join me up here. Someone asked a question earlier, but now the room's changed a bit too. Is how many lawyers are here tonight? Right. So there's a few hands. How many human factors experts are here tonight? I think we have one. And how many alcohol regulation policies, dram shop, police procedures experts do we have here tonight? And I'm a toxicologist. So our slides are not up. Help is coming now. Do you have the clicker? It's right there. Oh, it's here. Yeah, so we wanted to start with who we are. So I'm a toxicologist, human factors expert, police procedures and dram shop expert. You're looking at, together with me up here, some very brave individuals. And there was a discussion earlier about being the importance of attorneys being brave. And these two have bravely joined me in starting Exigent Forensic Consulting, along with our colleagues here at Exigent. I want to key in on that word, forensic, for a second. Forensic means, by definition, the intersection between science and engineering and the law. Right? It's as simple as that. And it's in part, in the right types of cases, the medical-legal interface. Right? So, whereas the law is the noble pursuit of justice, as scientists, we're involved in the noble pursuit of the truth, right? And so you heard from our physician panel the importance of intellectual honesty and applying that to the case. I think it's just a really cool area to be working in. I mean, what better place to exercise and execute than the noble notions of truth and justice. So, who are your experts? Right? That's a question for attorneys to ask. But I think, with all due respect to Abbott and Costello, who's not necessarily on first? I think a more important question is, what are the issues? What's on second, right? And I'll, for some reason, relegated to left field is why in the Abbott and Costello skit. But why do you need an expert? What are the technical issues that need to be addressed? And what are the elements of liability that you need the expert for? You need experts to establish and define what the dangerous condition is, to prove that the dangerous condition caused whatever the issue is in your case, the injury to the plaintiff. You need experts to talk about the violations of the standard of care and also notice. So I'm, as a toxicologist, largely dealing in the realm of causation. John will talk a little bit here about standard of care. And now I'm going to turn over to Dr. Grugle, Nancy, using human factors as an expert to make the point about having the right expert, the right subject matter expert for your case.
Thank you very much. As Mike said, I'm a human factors expert. I'm out of Colorado, formerly near Denver, soon to be out of Durango. I'm going to get pretty specific about what human factors is and how a human factors expert can be useful in your case, and how a human factors expert is going to help in a different way than another type of expert might. So some of the attorneys left in the audience may have used a human factors expert. I know Mr. Sorich has. And some of you may never have heard of human factors, so I just want to explain what it is. Put simply, human factors is the study of how people interact with technology in their environment. It's a little bit of psychology and a little bit of engineering. Most human factors experts are either psychologists or industrial engineers. The field is generally split in two. The majority of cases that I work on are transportation-related cases, but I also work on premises safety cases and product design cases. I could give an hour-long presentation on what human factors is and all these different types of cases. So I'm just going to focus really quickly on transportation. I will be the first person to tell an attorney who calls me if I am the right expert for the case, or if they would be better suited to a trucking expert or to a vehicle expert, or better suited by an accident reconstructionist. So in transportation-related cases, I'm primarily focusing on very specific issues that deal with driver behavior or atypical or unusual driver behavior, trying to explain why somebody did what they did. So I work on distracted driving cases, drowsy driving cases, driver behavior and decision-making, visibility, conspicuity, looming, and I also get into traffic engineering cases and autonomous vehicle cases. So an example of a case that a human factors expert is typically not going to be needed for is a very straightforward case where an accident reconstructionist can handle it. So for example, if there's a very simple case where a driver ran a red light, probably don't need a human factors expert. But if a driver ran a red light while they were talking on a cell phone, yes, you do need a human factors expert, because the distracted driving component of that case is not something that an accident reconstructionist could handle. Another example would be if a driver ran a red light with a traffic signal that was covered in snow. Then you need a human factors expert to explain why that driver did what they did. Did they have the information that they needed available to them? Did not run that red light. So to quickly differentiate between an accident reconstructionist and a human factors expert, an accident reconstructionist is primarily going to explain who was where when, what happened, did the vehicle brake or swerve, how fast were the vehicles going, and was the collision avoidable? Those are not issues that I address as a human factors expert, but questions that I answer would be primarily related to why did the collision occur? So for example, was the driver reasonably attentive? Were they distracted? Were they sleep deprived? When did the hazard become visible? Did the driver perceive and respond in a reasonable amount of time? Was there sufficient information available in the environment for the driver to avoid the collision? So for cases involving trucking, there is a very big difference between human factors and a trucking expert, but there also is some overlap. So for example, a trucking expert is primarily going to be dealing with standard of care issues, rules, regulations, training, truck driver actions. Whereas a human factors expert is going to opine on the science behind those truck driver actions. So to give you a couple of examples, in a distracted driving case, a trucking expert is going to opine on whether or not the federal rules or regulations related to using a device, texting while driving, talking on a cell phone, whether or not they violated some federal rule or regulation. Whereas a human factors expert is going to be able to determine, was the driver distracted, and was distraction a cause of the collision? For a drowsy driving case, a trucking expert can talk about whether or not the federal hours of service regulations were violated, but a human factors expert is going to talk about, was the driver sleep deprived, and was sleep deprivation a cause of the collision? Another example would be, and I come across this a lot in my cases involving trucking, if a truck driver failed to change lanes when they saw a disabled vehicle with flashers, the trucking expert is going to opine that according to their training, they are supposed to change lanes as soon as they see the flashers. So they violated their training. But a human factors expert is going to be looking at what distance could a driver perceive that they were approaching this disabled vehicle? And at what point could they tell that it was actually stopped in the lane of travel? And then lastly, I do a lot of cases involving traffic engineering. So basically, a traffic engineer is going to say what traffic control devices were required according to the MUTCD or some other local rules and regulations to be provided to the driver. Whereas a human factors expert is going to look at whether or not that the information that was provided by those traffic control devices was sufficient for a driver to avoid the collision. Another issue in traffic engineering cases is what do drivers expect to see on the roadway and what happens when what they're expecting to see isn't there. So I think I used up my 5 minutes and it was a mouthful. So
that was fascinating, actually. My goal here tonight is to give you a 5,000 foot view of a really sucky law in Illinois, and that is Dram shop. Which, if any of you are attorneys here, you know that you all hate it because of the monetary cap on dram shop litigation. With that, I say that all dram shop laws are written for the benefit of the industry. That is why they exist. Approximately 36 states have them. Some like this, Illinois is exceptionally protective of the industry, which is probably why we have so many bars on every street corner in Chicago here, because the industry can thrive. Other states, I know there was an attorney here earlier from Indiana. He is in a completely different situation, and the dram shop law in that state is very much more plaintiff friendly. Dram shop laws set the standard of care. Alcohol is unlike any other product, with the exception of probably cannabis, which is the brave new frontier at this point. But it's the only product where we have not one but two constitutional amendments where we talk about it. 21st Amendment throws the regulation of alcohol to each individual state, and so the standard of care is actually dictated by the Illinois Liquor Control Board. And so the standard of care here is a visible intoxication. But since it's a terrible plaintiff case, you don't see a whole lot of dram shop cases. But I've actually done cases in Illinois, and where those cases intersect is there is an additional factor from the patron, usually involving an incident of violence or of some breach of patron security. Because regardless of the alcohol factor, and the alcohol is the hazard here, the bar is still a business. It still has the responsibility to provide reasonable safety and security for its patrons. And so when you have an incident, for example, that you're thinking, the fact pattern that I specifically had in Illinois was a patron who was bombed out of her head at the end of the night after watching a MMA fight. She comes out into the lobby and perceives that another female patron, disses her and proceeds to have a shouting Donnybrook in the lobby, surrounded by security officers. The officers separate the two patrons. However, they dismiss both patrons at the same time. So we end up with the warring parties moving from the lobby to the parking lot. And the only thing that does is move the fight from inside to outside. The aggressor gets in her car, sees this other woman walking down a nearby aisle of the parking lot, proceeds to run her car around the parking lot, storm down the aisle, and run her over in her vehicle. So the question is, what kind of case do we have here? Well, we actually have a patron security case, which happened to involve an intoxicated patron. And really that's a what? What do we have here? And so the expert or the progression of the case revolved from that angle, and was very downplayed. Actually, was the actual dram shop factor of it. From police practices, the 5,000 foot view in Illinois and around the country today is de-escalation, something that was unheard of 5 years ago, and something that was practiced in Columbine with disastrous results. And so police agencies abandoned de-escalation and now have been being taught, aggressively approach every situation. Unfortunately, they haven't differentiated between terrorist attacks and mentally deranged patients. And in a police officer's career, their chances of encountering a mentally deranged patient needing medical intervention is much higher than facing a potential attack of a high school nightclub by a terrorist. Even though one will get you national headlines, the other one will get you, it happens every day throughout the country. And so what you're seeing is the federal courts are starting to take notice of this, specifically in the Ninth Circuit and the 10th Circuit. I don't know how the Supreme Court's ultimately going to look at this, but they're saying, there are times when the best approach for the police is to take a step back and reevaluate. And if they don't, that potentially is an actionable item for litigation. And so I think that's the hot topic in law enforcement, police practices going forward into the 2020s, into the second decade of the 20th century, 20th century here. And it's going to be an interesting one for both plaintiff and defense in civil rights matters.
I think we've used our time, and we shall move on to the next.